Good morning. My name is Ruth Diaz, and I'm with the Federation for Children with Special Needs. We have a special guest today, Dan Perlman. He's from the law firm of Moore, Perlman, and Gray. And, we go back a few years, Dan and I. He was at Mass Advocates for Children for a number of years, and his area of specialization is special education. So I'm going to turn it over to Dan. Welcome, Dan.
Hi.
Hello.
Thank you. Thanks for coming. So we're going to talk today about advocacy and how it relates to appeals. And when I say an appeal, I mean an appeal to the Bureau of Special Ed Appeals, which is an administrative body that hears special ed disputes. And whenever I give a presentation, I like to run it by someone first, just to make sure that everything looks good and makes sense. So I ran it by my resident expert, who's my daughter. Her name's Lily. She's 6.5. Don't call her 6. She's 6.5. And I showed her the presentation, and I said, Lily, isn't this cool how the words fly in and everything kind of goes together color-wise? And she said, yeah, it's okay. And I said, well, Lily, what's missing? What can I add? And she said, well, Dad, you need emojis. So this is advocacy to appeal with some emojis. So thanks again for having me. So we're going to talk about how to prepare your client and your practice for the potential for litigation. What lawyer, if a case ends up in a dispute that can't be resolved at the team level and a lawyer needs to get involved, what should we be thinking about as advocates in preparing a case for litigation, for potential litigation? So I'm going to talk about three things today, three main topics. First, the evidence. What is persuasive to a team and persuasive on appeal? The paper trail. What do you need to preserve your client's rights? And the process. What's helpful at team meetings? What have we seen that's maybe not so helpful in thinking about what happens if there's an appeal? I wanted to say first, as a lawyer, my experience is cases that break down at the team level, meaning a dispute, and not to say that it's someone's fault, more to say that things don't go as planned and an appeal is necessary, right? That's when a lawyer gets involved. So today when I'm talking about disputes, I'm talking about really big picture disputes. So for example, a student needs a language-based program, small language-based program, and the district is offering like a full inclusion program. So those are the types of cases we see the most of, so that's what I'm going to talk about today. So just keep that in mind. Some of this stuff might not apply if it's more nitty-gritty, like 2 times 30 speech language versus 3 times 30. This is more big picture placement dispute type issues. So I'm going to start with the evidence. This is arguably the most important part. What's going to be persuasive to a team? It's your roadmap to advocacy. What does the child need? Okay. So how do parents prove their cases to hearing officers on appeal? What do I look for as a lawyer when I'm looking at a new case? I start with what is the evidence? What evidence do parents have? Will it be persuasive to a hearing officer? And this is the same type of evidence that's often persuasive at the team level. It's sort of a trickle-down effect. School districts, their attorneys decide often, what is persuasive at the team level based on case law and a variety of factors I'm going to talk about now. So we know that independent educational evaluations are the most important piece of evidence for families. A neuropsychological evaluation is often the most important, provides a broad overview of a child's needs, right? When I'm starting a case, or when I get a new case, the first thing I'll look for in the evidence is, do they have an independent neuropsych eval? If not, it's not going to be a very strong case. We know from hearing officers that that's the evidence that they're going to look for most. So as advocates, I think, a similar first step in assessing how to advocate for a family's needs is to look at, do they have an independent evaluation, something to help understand a child's needs, help the team understand a child's needs, and have recommendations for what that child needs to make progress. From there are more need-specific evals that can supplement a neuropsych, but again, the neuropsych to me the most important. If a child has behavioral needs, consider a board-certified behavior analyst. If it's a case about dyslexia or reading disabilities, there are reading specialists, folks who have taught students who have reading disabilities, or speech-language pathologists. And then third, sort of in the range of most to least important, but still helpful and important, other experts involved in the child's care can be helpful, like a tutor. Some students might have a therapist who could write a letter, make recommendations. That's the type of evidence that a team is going to look at to say, okay, we agree or disagree with the parents. And it's the same type of evidence that I'll look for as an attorney when assessing whether parents have a case that can be appealed. You know, in a way, as a dad and a parent, it feels a little sort of unfortunate, but it's true that a parent's opinion doesn't carry much weight, right? It certainly doesn't carry much weight on appeal. And I think at the team level, it doesn't carry a lot of weight either. But, you know, it sort of cuts both ways, because having the independent eval is also helpful. It takes the pressure off a parent. I find that the parent's instinct is 99.9% right, you know, and so it often follows that a good neuropsych, good independent evaluation is going to be saying the same thing. So, but in terms of evidence, that's what you'll need to move a case along the team level or on appeal. So in terms of what type of evaluator we look for beyond just credentials, we know an evaluator must be credible. And what that means is, well, there are a few factors that hearing officers have talked about that we know as lawyers will make an evaluator credible, and that advocates should look for as well when helping parents locate an evaluator or assess whether the evaluator the parents have found is a good one. So first, we know independent evaluators should be neutral. So the first word in independent education evaluation, which is a term from special ed law, is independent. So we want someone who is truly independent, not someone who is too parent-friendly or too school-friendly. We want someone right in the middle who's neutral, who can see both sides of an argument and make an assessment about what a child needs without any bias. We know that an evaluator should be thorough. They should rely on sources of data, meaning assessment, maybe observation, district data, comparing data over time. That's going to be persuasive. If, for example, in looking whether students made progress in reading, it would be helpful to compare CTOP or Wyatt scores over time, and a good evaluator will do that and make that type of thorough assessment. We also think a good evaluator should be professional. So they should be, again, neutral, provide a balanced assessment, and also not take a scorched earth or, you know, attacking school district or parent approach, you know, and really focus on what the child needs without assigning blame. So why does it matter for an evaluator to be credible? What's the difference? Why does this make a difference? Again, I mean, it's more likely to resolve at the team level if it's someone that the district trusts. The point in all of this, in this presentation, is not just to prepare a case for a lawyer, it's to resolve it at the team level, so you don't need a lawyer. But they happen to be very similar in types of approach. So it's more likely for a district team to find a good evaluator, you know, to trust that evaluator if they're professional and balanced and neutral. It also, again, you know, the other side of the coin is it provides a next step. If you use a credible evaluator, but there's something clogging up, you know, the team process and it doesn't resolve the way it should, then it provides a viable next step for appeal if a disagreement persists. So how do you find a credible and independent evaluator? So certainly relying on other people's experience. I mean, we are a community here, and you know there are great advocates, experienced advocates and attorneys that can point in the right direction. If you're an advocate, joining another, which I'll talk about a little later, but joining a group of advocates and having mentors here at the Federation, or just forming your own group of advocates, I think it's a great way to you know, have a sounding board and provide referrals to each other. And you can also look at BSEA decisions. So you can, I'll talk about that now. So probably 5 or 6 years ago, right before I went on my own, when I was at Mass Advocates for Children, I created this website called Special Education Law. And you can go to specialeducationlaw.com or specialedlaw.com for short. And it's a search engine just like Google, right? You can just type in, it's plain language. You can type in really any word and it will figure out what you mean and come out with results that are hopefully consistent with what you're looking for. And you can type in an independent evaluator's name, right? So you can type in Dr. Smith, And hearing officers will say in their decisions, I found this expert credible or not. So that's sometimes a helpful starting point. You can also use a search engine to find a similar set of facts to your case and sort of help develop a strategy. I think it's a good thing, for parents, advocates, really everyone to read case law to better understand how the law plays out on appeal. Also, it's free. There's like no branding or anything. So, but yeah. So more on what evaluators should do. We know from hearing officer decisions that hearing officers sometimes give less evidence to independent evaluators who don't observe. There's a case out of Amherst where a neuropsych did an evaluation and found the student wasn't making progress over time, but the hearing officer found that that expert wasn't credible because he didn't observe the school district's program and didn't really have a good understanding of what the district could offer. On the flip, we have a case in Greenwood where the neuropsych did not observe, very similar set of facts, and the hearing officer didn't care as much. So it's 100% necessary. It depends on the case, but it's helpful to gather evidence and to have a better understanding of a student and what a district can offer. We also know, I think this is really important, we know that neuropsychologists and experts should talk with district staff. A good expert should really understand the perspective of the parent. That's very important, and should really understand the perspective of the district. To provide a neutral assessment of what a student needs and whether those needs can be met in a program within the district, they should really understand the district's position. And in that Norwood case, just to back up for a minute, in the Norwood case, the hearing officer said that where the experts really didn't get the information that the district had to provide, didn't really talk with staff, it was sort of a shot against that expert's credibility. So another critical step is, here are a critical piece for evaluators. This one's really important. Hearing officers have said that experts should testify. So when you're assessing whether an independent evaluator a student needs and whether those needs can be met in a program within the district, they should really understand the district's position. And in that Norwood case, just to back up for a minute, in the Norwood case, the hearing officer said that where the experts really didn't get the information that the district had to provide, didn't really talk with staff, it was sort of a shot against that expert's credibility. So another critical step is, here are a critical piece for evaluators. This one's really important. Hearing officers have said that experts should testify. So when you're assessing whether an independent evaluator is going to be helpful at the team level, ask that evaluator whether they'll testify. This is a big one for me as a lawyer. So just to back up for a minute, the first thing I do when I get a case is I go through all of the records and talk to a family about whether they have a good case to move forward. We call it a case assessment at our office. And what's really heartbreaking for us is when we see a case with an independent neuropsych, but that person either isn't credible or most often isn't the type of evaluator who will testify. So unfortunately, what we see is a lot of the teaching hospitals who we think of as great, right? Children's Hospital, Tufts, MGH, these sort of leaders in thought about students with disabilities. When it comes to the evaluation, you get often a postdoc who kind of disappears, or someone who won't leave the office or won't testify. It's a big problem. And so what we see a lot is we have parents who will wait 6 months to get these evals. Then it doesn't work out at the team level. They come to us. And the first thing I say is, I can't use this evaluation. We need to start over. And that is just really hard. So, I don't want to say avoid the teaching hospitals because they're good, and it's better than nothing, certainly. But I think that, be careful with those folks because sometimes they won't do the types of things we need to make a case if there's a dispute at the team level. So another thing evaluators should do is review records. And not just those records that you think are helpful, really take a look at everything, all the evaluations the districts have done, even if it cuts against your client's position, so they can provide a really big picture and thorough assessment of a student's needs. We also know that an evaluator should assess all areas of need, right? Not just academic. We see a lot of evaluators who, both on the school side and independent, who just look at reading and writing and intellectual potential. But we know from case law that IEPs are, there's this case out of Acton where the hearing officer said an IEP is a package deal. It must target all areas of a child's special needs, whether they're academic, physical, emotional, social. And in the Acton case, the hearing officer found, it was a dispute about placement. Parents wanted the placement at learning prep. And the hearing officer found that the school district's program was appropriate in terms of academics. But because it wasn't appropriate in terms of social emotional needs, it was enough to get a change in placement. So it's really important to assess all areas of needs, both for districts and for parent evaluators. So timing of evaluations is going to be important too. We know when possible, parents should work with evaluators early in the process. In Boston, a case where the parents placed a student out of district and then sought reimbursement, they didn't have an independent evaluation and got an evaluation after, and the hearing officer didn't like that. It's not fatal. I mean, some parents can do it that way, but in this case, the hearing officer took issue with it. So, better to, I think, give districts more opportunity, to see an evaluation if possible and to start evaluating early. We also know that evaluators who evaluate more than once, meaning if an evaluator did a neuropsych in first grade and then again in third grade, that's going to be more credible on appeal because hearing officers like to see someone who's been involved with the child over time. We also know that parents must use a neuropsych at the teen level or lose it on appeal. In the Richmond case, parents did not submit a neuropsych eval to the team level, meaning they didn't let a district consider that eval and then sought an out-of-district placement. And the hearing officer said, no, you have to give the district a chance first, which makes sense. So let's talk about the paper trail. So what do you need? This is also evidence. What do you need to create at the team level in case there's a dispute later? The most important part of the paper trail is the IEP response. There simply is no disagreement with an IEP if an IEP is accepted in full. So it doesn't matter if the parent concern section, or there's this, an email that says I really don't like this program, or none of that matters. A hearing officer will only look at an IEP if it's rejected or rejected in part. So they will not consider or look at or determine whether an IEP is appropriate if an IEP is accepted in full. When I give this sort of speech to parents at CPAC presentations, there's always a gasp in the audience. So I started adding this additional clause that says a family can change the response. It actually says it in the law too. Can change the response at any time during an IEP period. So you can always rescind your signature, or advise a family to rescind their signature and change the response to an IEP if they've already accepted it and there's a disagreement. So again, I'm talking big picture here. I'm not going to talk, I'm talking about big picture disputes. I'm going to go into detail about what an IEP response should look like. And so I'm talking about placement disputes, eligibility disputes, not disputes that have to do with 1 times 30 versus 2 times 30. These are big picture disputes. And I'll talk a little bit about the more nitty-gritty stuff, but most of this section of the presentation is going to be about those major disagreements. And also I want to point out that the partial rejection or full rejection of an IEP also preserves a parent's right to seek compensatory services. So on appeal, if an IEP is rejected in part and the case comes across my desk, I'm not only going to seek future services, I'm going to argue that the student is owed makeup services because they weren't given an appropriate program before, and the parents had put the district on notice via partial rejection.
So it's for that period when they reject to the point of the resolution of the matter, that time period would be available for compensatory services?
Yeah, so for example, if there's the 18-19 IEP is rejected in part, I can seek compensatory services for the 18-19 IEP, and maybe the 19-20 is rejected in part as well. It could be 2 years potentially compensatory, and then prospective relief as well. So if it's a big picture dispute, like placement, this is what I advise families to do, and advocates. When I work with, we work with a lot of advocates in our office. Advocates will refer a family to us, and sometimes will stay involved because I tend to say if it's not ready to appeal, keep me out of it, and then maybe it will resolve and no one needs me. That's great. So this is the type of advice we give to parents and the type of advice we give to advocates as well. So if there's a big picture dispute, there are 3 parts to an IEP response. First, I want to say partial rejection is the way to go. A full rejection is rarely appropriate if there's a disagreement. A full rejection means I disagree with everything in this IEP, go back to the old IEP. And hearing officers don't like that. They say there must be something parents agree to. It also is confusing to districts. And what do you do with the goals and benchmarks? I think a big picture IEP response via partial rejection is going to be best, and that's what we've found to be most effective, both at the team level and on appeal. So first, a statement. This is the statement that preserves a parent's right to seek compensatory services. So it's, I accept all of the services offered, meaning you're not going to pick and choose from the IEP, and I'll talk about that in a minute, but reject the IEP to the extent that my child needs services and supports beyond those proposed to make effective progress. It's a line we came up with at Mass Advocates for Children, and they still use, and I still use, and it works. Hearing officers just said, yep, this preserves a parent's right. And then I like to clarify that the parent understands that the district will implement the IEP as proposed. So they're not saying don't do anything. They're just saying there's a disagreement, and this is kosher. This is hearing officers have said this is okay. It preserves a parent's right without disrupting services. So the second part, I tell parents, right from your heart as a parent, lay out for the district, anecdotally, as a parent, really honest, why are you concerned? It's like the parent concern section. It could be the same, but a little longer. A couple paragraphs. What do you see? At home. What does your child say? Do they say I'm stupid? I hate school? Do they, are they grade slipping? Are they emotional? Are they not able to read? When you play a board game with them, do they get frustrated because they're not able to read the pieces? And it serves a host of purposes to write it this way. I think, as lawyers, I see a lot of lawyer letters that are very, stale and sort of unemotional. And, I've seen this sort of trickle down to some advocates as well, and I think that is wrong. These are kids. We should be talking about our kids in, in a way that makes them human, because they are. And so, I think this type of human language is really important because it brings it back to that. And maybe you pull the heartstrings at someone on the team too, and that's helpful, right? It's language I can quote too if I have to file an appeal, because it gives a human part to these cases that are human. So that's a really important section. And the third section is the omissions, also important. This is where you lay out your evidence. What are you rejecting in the IEP? I'm rejecting the omission of a small language-based program, an embedded social skills curriculum. And then what evidence are you relying on, as recommended by Dr. Smith? Okay. So a couple more points about the partial rejection. Length is going to be important. Short, concise, use bullets. There's this, I'm going to misquote this, there's a study that says the human attention span is like 30 seconds at a time or 3 minutes or something, so half of you were zoning out. No, I'm kidding. But that's why I'm dancing around, making lots of notes. But keep that in mind, both when writing, when at team meetings, and you want to hold the attention, make sure people actually read these things. I see letters sometimes that are 5 pages. I don't want to read that. There's no way, a teacher who has 15 meetings, in a week is going to read through that, really understand the crux of the dispute. So keep it short and concise. Focus on the big picture for big picture disputes. Okay, so if it's about a change of placement, right, subset versus full inclusion, or methodology, something major, keep it big picture. There's a case, this is not a very nice thing to say, but the hearing officer in this case is very blunt, said an IEP is designed to be a functional blueprint for addressing students' needs, not an encyclopedia. So in that case, the parent was rejecting goal number 3, benchmark, PLEP A, line 4, and the district threw up their hands and said, this is too confusing. It is confusing. Maybe I wouldn't have said it so bluntly, but I understand that perspective of, it's okay to make clear there's a dispute, but if there are nitty-gritty items, maybe a partial rejection letter is not the way to address that, because it just causes a lot of confusion. What is stay put? Where is the disagreement? Is it this big thing, or is it these little things? So I think, again, if it's a big picture dispute, keep an IEP response big picture. what if it's not a big picture dispute? What if it is about goal 1, benchmark 2, or 1 times 30 versus 2 times 30? What do you do then? So hearing officers have said, keep it at the team level if that's where the dispute is. Those aren't the type of matters where an IEP should be rejected in part over and over again. You know, that's not, those are, I think, and hearing officers seem to think, more, not unimportant, but they're important issues, but more minor issues that should be remedied at the team level if possible. Consider requesting changes informally or an additional meeting. You know, when you respond to an IEP, there's a box that says, I request an additional meeting. Not going to say it's going to work, right? It's still, these disputes can persist for a while, but hearing officers aren't persuaded by a dispute where there's just a vague objective or not measurable objective. Hearing officers don't care about that anymore. They care about big picture evidence. So if there's an issue with an IEP and whether a goal or benchmark is measurable, that's not going to make or break a case for placement. It's better to try and resolve those at the team level, if possible, or, you know, understand that maybe that's not a battle that can be won, you know, immediately, or you have to gather more evidence, that sort of thing. But I would avoid rejecting IEPs in part and picking apart sort of the nitty-gritty of an IEP, because it just leads to a lot of confusion and you know, and relationship issues at the team level. So let's talk for a minute about protecting information as advocates. Okay, and this is a hot button issue right now. I did a whole presentation on this, so I'm going to do a really small part of it, but we could do an entire presentation on this issue. There was a case that came down maybe a year and a half ago called In Re Dorian, and in that case, there was an advocate involved, a good advocate who does a really nice job working with the family, and there's a process on appeal in any area of litigation, but you know, same at the BSEA, where parties can seek information from each other, called discovery, right? And you can say, I want the district's emails, and the district can say, I want the parents' emails. It's horrible and not a fun process. But there's another part of that process where the parties to a dispute can seek information from third parties, meaning outside parties like experts, and that includes advocates, right? So we see a lot, school districts will subpoena, right? So a subpoena saying you have to turn over information as an advocate, right? So what do you do? And in Re Dorian, the school district attorney was seeking all of the emails between the advocate and the parent, and there were many emails. So here's what we know. We know that for attorneys, right, lucky me, they can't get the emails. I can't be subpoenaed. I am like an extension of a parent. We have attorney-client privilege and an additional protection called work product, which I'm not going to get into, but my emails with parents are protected, okay? But for advocates, there are no protections. There are no consistently applied protections at the BSEA. There's been some hinting at it. I think there should be protections, certainly, because it chills the process of trying to resolve at the team level, which is so much better than appeal. But there are, you know, hearing officers are at best split, and more accurately, I think, sort of right now, even though I don't agree with it, clearly favor that there are no protections for advocates. So if you're emailing with a client, understand that those emails could be seen by a school district if there's a big picture dispute and an appeal, and you're going to have to make copies of all those emails and send them over, which stinks. But in Re Dorian, at least 325 emails sent by parent to her advocate were subpoenaed, and the advocate had to turn them all over. So I don't know what they're looking for, but it's certainly a hassle, and yeah. So what do you do? Again, I have a whole presentation on this, but you know, be careful. Make sure parents, your clients, understand this. You know, so that they're careful in emailing with experts and with you. You know, keep it professional, and yeah, because they might be seen at some point if there's an appeal. So let's talk about the process and the team level. You know, are there strategies to resolve things at the team level and preserve your client's right your client's relationships with the district. So I have sort of a unique perspective in that I am an attorney, and I generally don't go to team meetings anymore because I don't think attorneys should go to team meetings because they make people uncomfortable, even though I'm really nice. It just creates, it makes it an adversarial process, which I think is not good. Certainly, I think advocates should go to meetings. I think I've seen some amazing advocates at meetings. But when I was at Massachusetts Advocates for Children, I did go to team meetings. So I've been to hundreds of meetings. And so I have a pretty good sense, I think, of what's helpful, and to talk about that now. So first I want to say why the relationship matters between a family and a team. From my perspective, on appeal, I know from school district attorneys talking to them that one of the first things a special ed director will do when deciding whether to resolve a case that's been appealed is talk to her team. And she'll say, you know, hey, special ed teacher, tell me about the student, tell me about the family. You know, what's the relationship been like? And it matters. I mean, should it matter in the eyes of the law? No, but it does, because, you know, someone is not going to resolve someone with your client if they don't like your client, right? It's more likely that you'll come to a resolution if everyone is friendly and professional. So it's also harder to resolve a case at a team level if people become involved, right? People emotions become involved, and you know, people feel personally attacked or insulted. You know, that doesn't work when it comes to persuasion and getting someone to understand perspective. We also know, and I definitely know from experience, that resolving one disagreement with a district team does not end a family's relationship with the district. So if an advocate or a lawyer or a family goes in scorched earth, you know, hoping that will resolve it, you know, that you're married to that district for the next, you know, 10 to 15 years potentially if the student's 3. So, you know, even if the student's placed out of district, you still have a relationship you have to maintain. How do you do that?
We do have a question
Oh, yeah.
where someone asked, is it true that hearing officers also have access to text between clients and advocates?
Yeah, there's some really unfortunate case law where I think sort of overzealous parents made the point that, oh, we should get district text messages, but then, you know, now everyone gets text messages. So, you know, I think it's unfortunate and incredibly time consuming. But yeah, every discovery request I see these days or subpoena requests text messages too. So those are not protected. Okay. So this this slide in thinking about team meetings essentially comes out of Harvard's clinic. They have a special ed clinic that I actually got to sit in on, and this is a decade ago. I assume they still do this. I still do it. I still advise clients to do this, and it's something they found was really effective at team meetings, and I completely agree. It's starting with an opening statement, and so the purpose is you want to make sure the district understands your client's position when advocating. And so that means, of course, partial rejection and the paper trail, so no one's surprised, but also a short opening statement at a team meeting is really powerful. Sometimes in a team meeting, the chairperson will say, okay, what are the parents' concerns? And that's a good time. Sometimes they don't. And I've advised clients, you know, just jump in. You know, just write an opening statement, a couple paragraphs, and say, thank you for coming. I really appreciate everyone being here. I just want to say this thing and go. Because it really helps to make clear what you're looking for from the beginning, so no one's surprised, and you can sort of control the you know, the topic of the meeting. And it's something to reference back to. So if the meeting sort of goes off the rails, you can always say, well, what about that thing I said at the beginning of the meeting when I asked for this, right? And it's really effective. So the 4 parts that should go in the opening statement are you know, describing your child and their needs, and you know, from a human perspective of what you're seeing. A very brief history if it's helpful. If it's a new team or you know, folks who might not remember history. Most important is going to be the current issues and what is your evidence. And it's really important here to separate the people from the issues. The issue is not that you know, the 27-year-old special ed teacher who's just trying to help, you know, is doing a bad job. The issue is that just the program's not appropriate because my child's needs are so significant, right? You know, don't pointing blame at someone is not going to get them on board with what you want, ever. So the last thing is a clear ask. what is it that you're looking for, right? That's really important. And I think it's often overlooked to just say specifically what you want from the beginning. And I like to include or have parents include a risk statement. The expert involved, or in my opinion, if we don't do this, my child is going to graduate without the ability to get a job because they can't read, or is getting up in the hospital. So how do we work together to help him today? So more about team meetings. Again, ensure the disagreement is in writing. A paper trail outlining your client's concerns is going to be really important. Partial rejection, that could be a short email going into the meeting so folks know what to expect coming in. Again, no one likes surprises. Stay polite, respectful, but firm. Again, easier said than done. These are very emotionally charged issues for everyone involved. But our job as advocates and lawyers is to stay neutral, be the sort of the voice of reason and understanding both perspectives so that we can advocate effectively, but also, to be the assertive voice because, that can be challenging for families too. Again, rely on your evidence, right? That's helpful for parents and advocates and lawyers. Take the pressure off yourself. It's not your opinion that the student needs, a different program. I understand your perspective, but Dr. X says, the gym needs a different program. I'm sorry, but I'm just here presenting the evidence, right? That's a really effective approach in persuasion, is taking the pressure off yourself and making about evidence. So in talking about staying kind and polite and firm, I want to talk about self-care for a minute. It's a little weird for a lawyer to talk about self-care, but I was raised by a psychologist and a special ed teacher, so I get some of that stuff too. So you can't take care of your clients if you don't take care of yourself, right? It's really important. Something we talk a lot about at the office. Some examples of things we do. Well, I would say first, this work for lawyers, advocates, it's rewarding, it's intellectually stimulating, it's stressful, it's isolating, it kind of it's sort of a circular way. And so, this stuff is really important for everyone and for your clients too. It's great advice to give to families. I've had, I had a parent who said to me, advocating is a full-time job. And I said, advocating as a parent is a full-time job. And I said, no, it is not your full-time job. Take a day off. Go running or spa or whatever is going to help you, because you can't advocate for your child or your client if you're not taking care of yourself. So, some examples from our office. I meditate. Sherry at my office really meditates. She's amazing. I think Michelle does too. We all sort of do our little meditation practice. We're all into fitness. We have Sherry rows. I lift weights. Michelle runs. Jackie who's here today hikes. Kate is like a boxer. So like everyone has their, being physically active I think is really helpful. I think collaboration is really helpful. We talked a little bit before about having an advocate group. For us, having sounding board, having people around, being able to talk to people. Don't be isolated in this practice because it's really stressful. From the experts, again, this is me as a lawyer. I'm not an expert on stress and mindfulness, but there's an expert who I really like. She wrote a book. I'm going to butcher her name, but it's in the slide. She wrote a book called Stress Proof, and it really runs the gamut on she took all of the research and just poured over what she thought was credible in terms of understanding human stress and how to resolve it. And she talks about like anti-inflammatory diets and playing Tetris to take your mind off stress. And it's really interesting stuff. I don't do all of it, but it's worth a read. So I'd say check that out. Okay. So what if I can't get to an agreement with the team? What do I do? So first I would say, go through what we talked about today. Do you have the evidence? Do you have a credible independent evaluator? Do you have the paper trail? Is the IEP rejected in part? Have you gone through the process in a way where there's a clear ask and the team understands what your client's looking for? What if a disagreement persists? That doesn't work. You have mediation, can be a helpful process, right? There are mediators at the BSEA who can come to try and resolve a disagreement outside of the team process. I've seen that be really successful. There are facilitated team meetings. These I think are reserved for where there's a lot of emotion and sort of human disagreements, and you need someone at the team process. A team meeting can kind of move things forward. That can be helpful. And then I put due process last, right? Referring to an attorney and due process for a reason, because this is the last result. I think going through all of these steps and trying to resolve the team level is most important. But then, yeah, of course, parents have the right to appeal a team decision, and I would say that is the point where you want to refer to an attorney. Yeah, questions? Yeah.
What do you see as your biggest, what do you see as your biggest problem, over the years as an attorney, working with advocates? What is,
So she asked,
like if you had your wish to try and fix things, or what would be a better situation?
sure. So the question, what is your sort of the biggest issues I've seen in working with advocates? I guess, the hardest thing I've seen is when a case comes to me and the evidence isn't there, right? And either, yeah, and I think that, there are a lot of, I think the best advocates that I've worked with are those who will just call me or email me, even if we're not working on a case together, and just be like, what do you think about this? Or what do you think about this expert? Or they work with a group of advocates who have worked with lawyers before and sort of know what the appeal process looks like. And so they know, what experts are going to work at the team level and also work if there's an appeal. Again, the hardest cases for me, most of my cases are referred by either advocates or experts, is when I see a case and it just doesn't have an independent eval, or it has an eval from Children's Hospital, and it's a good case factually, but I can't move it forward because it's lacking the evidence that I know to be credible. So I would say, as advocates, really have your finger on the pulse when it comes to what is persuasive if an appeal is necessary, and what experts are good and which ones, have had challenges both on appeal and, even at team meetings.
Also, what about holding on to cases too long when you do have the evidence, right?
That's hard too. Yeah, we see cases that come too late. And I think what a lot of advocates don't realize, even some lawyers don't realize, is the BSCA is really backed up. Okay, so if I'm trying to get a placement, which most of our cases again are about placement, if I'm trying to get a placement for September, I have to file the appeal in March of the previous school year. Okay, to even get a date close to summer, right? Even that's late at this point. So if a case comes to me in March, I'm scrambling, right? And maybe that's enough time. If it comes to me in May, there's no way. It's not going to happen unless parents are unilaterally placing. So I'm hesitant to say refer to lawyers early, but talk to a lawyer and say, is this a case that should be referred early? Have a community of advocates, have resources of attorneys. Build yourself a little community so you really understand what the process is going to look like and what timelines are going to look like.
I was a little concerned when you talked about the BSCA not looking at the lack of measurable objectives as an issue to come before them. So what it sounds like to me, it's an effect that's trickling down, that districts are not being responsive to families who say, how will I know that my student has achieved this benchmark when they're not really measurable, and the family's asking for data and numbers of times and things so that they can see their child is making effective progress, versus waiting till that end of the year and realizing, oh my gosh, the student did not make measurable progress.
Okay, so let me rephrase. I think that it does matter on appeal. If the goals are very vague and maybe repeated year after year, that could be evidence that a student's not making progress, or that the district doesn't have evidence that they've made progress, right? That definitely can be an issue on appeal. It's part of the appeal. It just doesn't make or break a case. So it's definitely something that can be disputed on appeal, that I bring up in appeals if it's part of the case, but it's just not the biggest piece. And the biggest piece is going to be the evidence through an independent eval. Yeah, I'm glad you asked that question. That's a really good one.
We have two. Someone would like to know, do you maintain a list of credible independent evaluators?
Mm-hmm. I do, yeah. There are some evaluators who I've seen, I've worked with on appeal, and other lawyers who I trust to work with on appeal. and who just pick up the darn phone, you know. So yeah, I mean, yep.
Do any of them take the state rate?
Oh, I know,
No.
which is improved now,
Yeah.
given the change in the law or the change in the rates, but it's still way too low, and yeah, there aren't a lot who take insurance either. It's an issue. Sure.
Sometimes.
Yeah.
This may be a bit off topic, but what happens if a student is turning 18, has 2 more years of school to graduate, and wants to pick his school placement, even if it's not appropriate, and the school supports the student?
Okay, so so students turning 18, so they would have educational decision making, and they want to choose their own placement, and the district says okay, essentially, and the parent is like, what do I do, or what the advocate's saying?
Yeah,
Right.
I'm guessing that the advocate or parent feels it's not appropriate.
Right. I mean, depending on the student's needs, there could be a guardianship dispute. You know, if the parent feels that their child isn't able to make those decisions, you know, they could seek guardianship if that's a way. But beyond that, when a student turns 18, they do make the decisions. So that's, in terms of the law, you know, a parent really can't do anything unless the child signs over their rights or there's a guardianship.
Okay. If an advocate or family wants to appeal that a district is only offering a 504, and we feel an IEP is needed, is the appeal process any different?
This is a really good question. So eligibility. So our practice is, I would say, 90% placement, 10% eligibility. Those are really the two big picture issues that lawyers work most on. So the appeal process is the same. You know, it's, do you have a good expert who supports that a student needs an IEP versus a 504?
So it comes a battle of the experts. If the school expert
Right.
says no and the independent expert says yes,
Yeah.
It ultimately will go whether that independent expert has observed the child, spoken to the school, and can testify or be present in a formal process going forward, because the school district's going to say our expert says no. Right.
That's right. And one thing I should point out too is, just like any area of civil litigation, special ed disputes are no different, right? So 97% of these cases settle, right? And the case law is pretty set at this point. So what happens when I file an appeal is I'll call the district's attorney, or we'll sit in front of a hearing officer, and they will analyze the case and say, you know, this expert won't testify, or this expert isn't credible, or this expert is credible, or this data is good on the school side, or bad, you know, good on the parent side. And, you know, cases, it's like we talk about what would happen at a hearing, like we're doing today, but 97% of these cases resolve without a hearing, because as lawyers, we have such a good understanding at this point about what makes a case strong or not, which is good, because hearings are expensive and uncertain.
And families struggle to win in that setting because the districts control a lot of the data.
That's right. Absolutely. Yeah.
Any advice about getting the team to accept the diagnosis of dyslexia when all the characteristics are present, but the school still refuses and will only state developmental delays for an 8-year-old?
Yeah, yeah. I just had a lot of disagreements about, you know, sort of labels. I don't know. There are certain diagnoses that make more of a difference, like autism, right, because of the autism law, and dyslexia sort of a little bit, you know, sort of with the specific learning disability, and so that the stronger parts of the law for that. You know, I don't know enough about this matter to really advise, but I do sometimes advise, you know, maybe the label isn't worth disputing and to focus more on the services, because sometimes there are reasons that I don't understand where, you know, there becomes a label dispute and people just dig in for whatever reason it might be, and sometimes taking an end route, you know, sort of you know, focusing more on what services the student needs versus the label is more effective. Because in terms of thinking about an appeal too, you know, I couldn't appeal a label, right? A hearing officer would want to know about the services. So I think that's, you know, taking that, yeah.
Another question. I was recently in a team meeting and questioned why there were no end dates on the benchmarks. They state their models. They state the model they use for goals and benchmarks in the district don't require them. Have you ever heard of such a thing?
No, that's interesting. Districts, there are a lot of sort of funny things that happen, and sometimes it's people not understanding the law or trying to reshape the law. We saw procedures light on us. Folks remember that?
Yeah.
Oh my goodness. So with any area of law where there are protections of rights of people, there's always going to be people trying to change those laws, and so yeah, I mean that's clearly inconsistent with the law. The law clearly says annual goals and benchmarks.
That's something a family could contact the Department of Education around.
Yeah.
That they're not following an IT.
Yeah. Yeah, I think if it can't be resolved through sort of explaining what the law says, I think the black letter law says annual, teams should develop annual measurable goals and benchmarks, and annual clearly means 1 year, right? So if a team isn't doing that, I mean that's one of those rare circumstances where it might make sense to actually quote the law to help someone understand it. But if a district says, no, we're doing it differently here, and it affects a student's education, then yeah, I think that would be one for PQA. Seems pretty straightforward.
And,
or PRS, sorry. They changed it.
You covered this earlier, but someone did ask, what would you consider a qualified expert for evaluation?
So, I mean, I think sort of a generalist, again, is a neuropsych, right? So, starting with a neuropsych eval is for 99% of cases makes sense. So, that's going to be number one. Do they have the right credentials? Did they do I didn't get into this level of detail, but, a good neuropsychologist should have done a postdoc in, neuropsych testing of children, not, adults, that sort of thing. So, and then all the other factors I talked about before, that make it an expert credible.
And do you advise parents to write an agenda prior to the IP meeting when they partially reject and include the written response in their ask and risk prior to the IP meeting? Yeah,
so sometimes if the dispute is not clear, then sometimes it makes sense to start with an email, saying, this is what I'm thinking about. It might be the agenda for the team meeting. You don't want to say this is the agenda, right? Because it's supposed to be equal. But certainly, yeah, as I said, people don't like surprises. So that opening statement is helpful, but only if there's already sort of understanding what the disagreement is. If you say in your opening statement you want to change in placement, it's the first anyone's ever heard of it, it's probably not going to resolve at the team level that day anyway. So yeah, I like that idea a lot of sending along, an agenda or some sort of talking points before the meeting so folks are prepared going in.
And someone stated, I literally just was hired for a client for a 17-year-old boy with social emotional issues. He's failing 3 subjects, but what he really needs is an outside therapeutic placement. I'm concerned that the mediator will focus only on him failing the 3 subjects, and that the fact that he's crying all the time in school, and ignore that fact.
Right.
I have a letter from his therapist recommending the therapeutic placement,
right.
And how would you address that?
Okay, that's a good question.
The mediation is next week.
Okay.
Nothing like it does.
Right, exactly.
Right.
Mediation is today at 1 o'clock. So yeah, I mean, I think that opening statement that you can apply to team meetings, I apply that to mediation as well, right? Focus on maybe the district's going to focus on academics. Don't focus on academics. Focus on the child's social emotional needs. They've been hospitalized. If they're not attending school, it doesn't matter what their grades are if they're not accessing. They're not going to change. If you make accommodations if the student's not there or sort of is emotionally not able to access, right? So that's helpful. Focus on the piece of evidence you do have. Sounds like the therapist's letter. If that's not effective, at mediation, which it might not be. I mean, I don't know enough about this, but if it's not, then I would go through that list of, do I have the pieces in place to make a credible case? And, maybe if the dispute is academics versus emotional, a good neuropsychologist can sort of pick apart, what's most important for the student, and that might be persuasive either to the team or mediation.
Do you have any luck with getting experts to participate in mediation by phone?
Yeah, I think that can be really helpful. So some experts, I think sometimes teams feel like, well, we don't know this person, they're an outsider, and sort of have them at the meeting can be really helpful, or calling in, so people can see that they're credible. Yeah.
If an attorney wants to gain experience in special education law, would you recommend first acting as an advocate to gain that experience, or any other thoughts?
Yeah, I think, oh boy, I'm gonna get in trouble here. I think if you're an attorney, you're an attorney. I mean,
Yeah.
okay, good.
Yeah.
Wrong.
The attorney say yes.
Okay, good.
So how about contact with the other side's, clients? If you're an attorney,
Right, there are
switching hats is
ethical
not a good
issues.
idea.
Yeah, I totally agree. There, and I mean, there are some good attorneys who are good advocates, right, at team meetings, and can do, that really difficult job as well. But I think it's disingenuous to say I'm not being a lawyer today, right? To say I'm not wearing that hat today. I don't think that works. And there are some ethical issues involved too. So I would say if you're starting out and want to learn, I have a good answer to this. If you're starting out and want to learn how to be a good special ed attorney, volunteer at the Federation or one of the other nonprofits to, take some pro bono cases and, seek out some advice from those folks, to better understand what the process looks like. And I think that's a good way to start. Yeah.
I had a question on, after, as part of the process, you talked about ensure that your disagreement is in writing.
Right.
So you're in a team meeting, you realize you're not agreeing on certain things, but you're there to talk about that IEP that they're under an obligation on law to deliver to you in 45 days.
Right.
So they're going to say, well, we're not agreeing, but you have to wait till you get the IEP in place, in the mail, and then you have the right to reject.
Right.
But you're not really documenting in writing the disagreement until you partially reject.
That's right.
That's what you meant by partially rejecting and documenting in writing in your rejection the disagreement.
Correct. Yeah. If there's a disagreement at the team level, right, and you're saying, no, I want a different placement or, different services, then you accept the IEP, it essentially undoes what, because there's no real record that's, saying binding or, to preserve your rights.
Earlier though and send the district an email
saying,
thank you for meeting today. I really would like to have an additional meeting to discuss our disagreement, whatever. I think they're going to move forward with the IEP and deliver you something in writing as to their expectations. So.
Oh, like an animal, you mean the district?
Yeah.
Yeah. I mean, I think it's always good to create your own paper trail. The districts have an N1, right, a narrative description of what happened at the team meeting. I think, some parents and advocates will write their own N1, or they'll, I think maybe it may be a little overkill because you can just respond to the IEP, and within the IEP response, you can, correct, clarify any facts that were in N1. But yeah, I mean, I think sort of the most important piece of the paper trail is going to be the IEP response. But, certainly, there are steps along the way, like if a student is really struggling, but parents don't say anything until an IEP response, that's not great. So, having, I think daily is too much, but, certainly, there are some circumstances maybe that necessitate that. But, if you're seeing ongoing challenges, any concise email, right, or updating your concerns or, or a letter, I think is a good thing to do monthly or bi-monthly.
You could reply to a progress report.
Right. Oh, that's a good way to do it. Yep, that's smart. Yeah.
Thank you.
Any suggestions for a family stuck with a tester who verbally expands information in exit meetings, but won't put changes to add these things in writing for the parent to present at the team meeting? By phone, he says he will share with the team and or at mediation. Mm-hmm. Any advice? Why would a tester not put anything in writing?
Okay, so an evaluator is saying they have recommendations, but they're not going to put it in writing. That sounds like not a great evaluator. That's a big red flag to me. I mean, if they have an opinion, they should put it in writing. Yeah. I mean, I guess it's better than nothing to say it at a meeting, and then you could follow up and say, as they said the X, create the paper trail for them, but it's not a great sign. I mean, thinking about, if there's someone who's going to testify, but they don't feel strongly enough to write it down, that's not a good sign. Yeah.
And one of the challenges for parents and advocates is finding a place for individual for a neuropsych, especially in Western Mass.
Yeah, oh yeah.
What would you suggest?
Yeah. I mean, we have cases in Western Mass, and we have them travel, it stinks, but traveling to Wellesley from, Orange, and it's hard. I mean, there aren't a lot of there are a couple, good evaluators in Western Mass, and I mean, there are just a couple of evaluators, period. So, But yeah, I mean, I be a broken record here. I mean, rely on your networks and talk to experienced lawyers, experienced advocates, because there are a lot of evaluators. Some really great, some not great.
It's not like you have to go continuously. It's like a couple of trips.
Right. Yeah. Exactly. That's right. Yeah.
I understand that Boston Neuropsychological Services will accept state reimbursement rates for comprehensive neuropsychological evaluations. Do you have any experience with this group or any recommendations regarding the services of specific neuropsychologists within this group who produce high-quality reports that are credible in a hearing setting?
These questions are getting like more and more concise. They're trying to nail me down. Good job, guys. So actually, I don't think I want to get into specific names during this presentation, but folks can always email me.
Feel free to type any other questions in. That's all I have here.
Thank you.
Cool. Thanks. Thanks for having me.
All right.
But thank you.
Thank you.
Thank you.
You need an emoji at the end.